Call the next case, please.
Katherine Sanko versus Clinton Sanko.
We'll hear from the appellant.
All right, I would like to reserve 5 minutes for rebuttal, if that's okay.
Yes, that'll be fine.
My name is Lucy Wright. I represent Katherine Sanko, and this is a pretty tragic story about the Sanko family. There's 3 teenagers under the age of 18. Dad filed a petition requesting custody of the youngest child, who's 14, Brendan, and the oldest child, Alyssa, who turned 17 the day after court. And the reason he filed is because they wanted to live with him. Now, there was a 2015 order that this court put down that allowed Katherine Sanko to move to Pennsylvania, where all of the family is, with the 3 children. And that was in 2015. And she moved there, and Dad would come up and visit. He would see the kids pretty regularly. He talked to them on the phone, I believe he said daily. He would FaceTime with them. There was never any problem. He never petitioned the court in those 7 years for a detailed parenting plan. He didn't need it because he'd asked for time and Mother would grant that, and they managed to get along de facto with a parenting schedule for all those years.
So after the Court of Appeals issued its opinion, whose burden was it to make sure that the PPP was formally modified to be in compliance with the opinion?
The Court of Appeals had directed the trial court judge to make sure that the parenting plan was put down, that actually adopted the move and put in a new schedule, and for whatever reason, it never was. It just fell through the cracks. Neither Mr. Souser nor myself were attorneys in the original divorce. So that was the burden of the court to do, and she never did it. And nothing was going wrong. Things were doing good. The kids were doing great. And then Dad files requesting custody of the youngest and the oldest, not the middle child. And the burden on him was to prove that there had been a material and substantial change of circumstances that somehow affected the best interest of the children. The burden of proof was on him. The court found that there was a change of circumstances. And oddly enough, the change of circumstances was the move to Pennsylvania. But the problem is, that was totally allowed. My client filed the request, the letter to move. There was a hearing in Chancery Court at the time. She was initially denied to move. She appealed here, and this court said, yes, you can move. You can move with the children. So she did. And for 7 years, things just rolled along.
If we put aside the initial move to Pennsylvania as being the change of circumstances, would you not agree that there were lots of other things that happened in those intervening years that could also be considered material changes in circumstances, including the fact that the mother and children moved within Pennsylvania several times, and then also to Georgia? I think we have Dad getting remarried. We've got just an increase in age as the kids mature. Those things can all be material changes of circumstance.
They are, and I would not disagree with you, but the problem is those changes were only material enough to maybe change the schedule, not to change the primary parent per the statute. So the changes that were going on were pretty minor, and the kids were doing great. Alyssa makes straight A's, Brendan does well. All three siblings get along with each other. They have good relationships. And the court put in its order the direct reason for the change of circumstances was that move that everybody knew about. And so from there, what the Court of Appeals, what Chancellor Fleener did is she weighed all of the 15 factors and did a full comparative fitness analysis for purposes of changing custody. And when you look at the
I'm sorry,
factor,
before we get off that, did the trial court find what did the trial court state was the material change in circumstances? Was
the
it just
move to Pennsylvania,
was that the only thing the trial court found?
that was it.
That
and
was the material change in
it
circumstances?
was direct. It said everything was going fine for 7 years, and then the mother moved to Pennsylvania 600 miles away. That is the change of circumstances. That was what she pointed out. The other minor issues were not really addressed in any kind of detail. When the chancellor weighed all of the factors, I thought it was pretty interesting because she weighed 5 factors in favor of father. And then all of the other factors were not applicable. And she did not weigh 1 factor to the mother. So we've got factor number 1, which is the extent which parents have performed the majority of parenting duties. That's mother. And she found that that just wasn't either one over the other. The second one is the potential for parents to follow past orders and future orders. Well, for 7 years, Katherine Sanko worked with Mr. Sanko in making sure he spoke to the kids, FaceTimed the kids, saw the kids perfectly well. Nothing went wrong. So she proved that she has the potential for following court orders and the potential for making sure dad's included in the kid's life.
Let me ask you this. We've got 2 kids here, one of whom I think is about to age out, correct?
Yes.
April
11th,
So
yes.
are we, for practical purposes, just dealing with the younger?
We are. My client knows realistically that by the time the decision comes in, it's going to be right there at the time of school ending, and she would never disrupt the children. But the sad thing is, she's lost her whole senior year really for no reason. All she did was move.
What do we do when we have a child's preference and we've got the court giving that some pretty substantial weight? How are we to review that?
Well, the court gave the preference of the children much stronger weight than any of the other factors, and it even said so. It relied on a case that was totally distinguishable for what was going on in this case. And both of the children actually testified in court live, and both of them said that the reason they wanted to live with their dad was just because they didn't see him enough, just because they thought it wasn't fair. That was both of their reasons. So that's a frivolous reason, and the court should really only consider the reasonable preference of a child over 12. And the preference was not a reasonable preference. It's not like the children were not getting along with their mother. It's not like their mother married some horrible guy. Nothing like that. They just kind of felt it would be more fair.
So is it unreasonable then for a child who has spent the bulk of their childhood with one parent? Are you saying it's unreasonable for them as they have matured to make a decision to say, you know what, I think it's time for me to spend more time with the other parent?
No, I agree with you. I mean, it is reasonable. If they feel like they want to spend more time with one parent, they should be heard. But the problem is for that really to be the controlling factor. And the statute's pretty clear. It says that the court should only even use that factor if there's a reasonable preference. So she gave a lot of weight to that, cited a case that was distinguishable. The fact that she did not give any of the factors toward my client, did not weigh any of them in her favor, was pretty disturbing on that. You know, she didn't consider the other sibling who's living in Pennsylvania, who they get along with. None of it. So that was her decision after weighing the factors, and I'm asking for the Court of Appeals to reverse that and remand it back for her to consider adopting the parenting plan that we proposed, because it's what they were doing, and the children were doing fine. And I think that's all my time.
You have your time for rebuttal. Hear from the appellee.
May it please the court. Good afternoon. I am Robert Sauser from the Chattanooga Bar, and it's my privilege today to represent Clinton Sanko, who is seated to my right. He is the father of the children in this case. We're talking about Alyssa Sanko, who is 17, and her younger brother, Brandon, who is 14. Both of an age where they are entitled, if not encouraged, to express a preference to the court and for the court to hear their preferences. And the court did in this case. Although it wasn't put this way by the trial court in her original opinion in this matter, it was stated by the chancellor in her ruling later on Ms. Sanko's motion to stay. This appears at volume 2 of the technical record at page 210. This was not a close call for the court. I found that it was clearly in the best interest of the children to move with their father. They are wanting new experiences. They are chomping at the bit to move, and I'm denying the motion to stay.
What do we do with the court's statement in its opinion? Here the court finds that a change occurred after entry of the order sought to be modified, i.e. the 2014 PPP, because in 2015, mother relocated to Pennsylvania with the children. That is the basis upon which she found a material change of circumstance. That's just weird.
I understand that why Your Honor perceives it that way. I would point out that the court did find and stated at page 6 of her opinion, in addition to that statement that the court referenced, from all of the above, the court concludes, father has demonstrated by a preponderance of the evidence that there has been a material change in circumstances. So yes, I understand that she did at one point make that specific comment, but she later on broadened the reasons for her ultimate decision by saying from all of the above, and that included her analysis of mother's move from one location that was only 20 minutes away from father's parents' home to a location that was an hour and a half away. And that appears at page 5 of the court's opinion.
Let me ask you this. If we, I understand what you're saying, there's other things in the order that she sort of broadly refers to, but if we read this order as saying really the material change in circumstances she references is the 2015 move, and if we say that was error, what is our remedy? Can we read the record ourselves and independently say there's lots of other material changes of circumstance that the record supports? Or do we have to send it back to the trial court to say, hey, this was wrong because that went up on appeal and there's a whole opinion on it. You need to reconsider that again. What do we do?
I think this court certainly has the discretion to look at the entire record as a whole, not just that one. And if the court concludes that it was wrong for Chancellor Fleener to make that statement, that the reason for finding a material change in circumstance was the original move to Pennsylvania, then I think the court should go ahead and look at all the other changes in circumstances that the evidence for which appears at other places in the record. And there are many.
Or could she have done that because the PPP was never modified in accordance with the Court of Appeals opinion?
She may very well have. She did not elaborate, but Your Honor makes a very good point. We're faced with a circumstance here where father wanted to modify and change custody. The only order that appears in the record anywhere, in this case, from the beginning to the end, the only permanent parenting plan that is in this record was entered in 2014. So if you're analyzing...
That's so, only because our opinion was ignored.
I don't think it was ignored, Your Honor.
Well, did anybody do anything about it? I'm not saying it was your client that ignored it or the other side that ignored it or the trial court, but it sure seems like nobody paid any attention to that particular part.
Well, Your Honor, I think the trial court did, in a way, in a subsequent hearing that involved the older child, Connor Sanko. An order was put down, and it invited both parties to file a motion to modify the 2014 parenting plan. Now, the court at that time didn't set a hearing date. I acknowledge that. And for whatever reason, the court did not follow up on entering a plan. Mother did not either, and father didn't either. The reasons for why that happened do not appear in this record. All we have is a 2014 plan, and then 7 years later, a petition to modify.
Well, not exactly. We have the 2014 plan, and then we have this court's order allowing her move.
Allowing her move. But in terms of, so what do you compare it to? If father wants to modify the petition, he's looking to modify the 2014 order. That's the only order that's in the record for him to modify. What's different now than it was in 2014? Well, the biggest difference is instead of the parties living 6 miles apart, they live 600 miles apart. I think it's...
Which this court had already allowed.
Which the court had allowed.
Look, I think I'm arguing now on this. And let me ask you back. You mentioned part where you said the court didn't rely on just the mother's move to Pennsylvania. It said from all of the above.
Correct.
Would that from all of the above also would still include the move to Pennsylvania, wouldn't it?
It definitely would, Your Honor. It definitely would.
How do we cut that out?
Well,
I mean, the trial court didn't.
I understand that, Your Honor. But I look at what father's remedies could be. If you say father is precluded from filing a petition because nothing was filed in the meantime, it leaves him without a remedy. So he needs a remedy.
Why couldn't he file a petition saying here are material changes other than and not include mother's move to Pennsylvania?
And he did. And that evidence is in this
But
record.
I'm sorry, he filed a petition that did not talk about mother's move to Pennsylvania?
His petition simply said, it referenced primarily the children's preferences because they were now of an age to not only express an opinion, but I mean, one of them was nearly 17 years old at the time. In 12 months, she's going to be an adult. And she ought to have, at least in father's view, she ought to have had a say in where she wanted to live for that last 12 or 13 months. Aside from the original move to Pennsylvania that happened in 2015, we have the moves that mother made after she moved to Pennsylvania. The one that affected father the most was the last move, where mother moved. Before mother's last move, father was able to visit once a month. He could stay with his parents, who lived in reasonable proximity to where Mrs. Sanko lived. It was a short drive, about 20 minutes. So he was able to visit with the kids every day. He'd go up for a week and visit with them every day during that week. Well, mother then moved from that location to Monaca, Pennsylvania. That was about 90 minutes away from where father's parents lived, which was his home base when he went back to Pennsylvania. Well, that precluded him, that extra 2 hours of driving time, 1 hour there and 1 hour back, significantly impacted his ability to see the kids on weekdays. He was still able to go up and do it on weekends, but he went from being able to visit essentially for a week to only being able to visit a weekend. A very significant change in his ability to parent. And we believe that that move by mother, by itself, is a material change in circumstances that did not exist in 2014 or 2015 after mother moved. Father was still able to see the kids basically 1 week out of the month. And he could no longer do that after she moved that far away. Now, we've got an almost 17-year-old at the time of trial. In fact, her 17th birthday was the next day. And a 13-year-old who was about to be 14 in 3 or 4 months at the time of trial. Their testimony appears in the record. The judge heard the testimony, was able to evaluate the demeanor of these children. She was able to decide for herself, were the children credible? Were there reasons for wanting to move to Tennessee to live with their father frivolous? She found they were not. And Mr. Sanko suggests that the standard for this court is there evidence in the record that supports the trial court's ruling? And we think there is ample evidence here to support the trial court's ruling, both on change of circumstances and with respect to best interests. And the best interest analysis was telling. There are 15 factors that are enumerated in the statute. The court found that 10 of those factors were either not applicable to these parents or did not weigh one way or the other. That left 5 factors out of the 15. The trial court found all 5 of those factors to be in father's favor. And we strongly believe that the only way that this court, seems to me, can rule against Mr. Sanko here would be to find that the trial court abused her discretion in making those conclusions. Now, in our brief, we have a pretty good bit of the factual part of it is quotations directly from the trial court's ruling, and those are in boldface in the brief. And each one of those is followed by a citation or citations to the record where there is evidence that supports the trial court's statement. And so all of the rulings that were made by the trial court, all of the findings that were made by the trial court are amply supported in this record. And we encourage the court to examine the record closely. We believe that a fair conclusion to be drawn by an objective analysis of this record can only lead to one conclusion, and that is that the trial court needs to be affirmed. If there are no other questions from the court, then I will conclude. Thank you very much.
I hear none. Thank you. We hear from the appellate in rebuttal.
When the court issued its decision,
Pull the microphone down just a little bit. Thank you.
is that good?
Yes, thank you.
Okay. When the court issued its decision, it is very clear that what it relied on was that move that was already blessed and addressed by this court. And my client simply followed this court's directions in moving.
Well, nobody did, frankly. Nobody followed this court's directions. They did, and she moved, but it appears from everything I've seen, I can't speak for the others, but that they were able to work it out, and I understand what happened. They were able to work it out, and they resolved it, so because of that, they never went back. Nobody ever went back and got a new plan. PPP actually entered. And I understand things were working, so.
That's interesting as well, because one of the factors that the court found in favor of Dad was the potential of following past orders and future orders and the potential of encouraging a relationship. And obviously Mother did that. She was the primary parent, but Dad was getting to see the kids as much as he wanted, essentially. There might have been a few times that she had to decline, but she just worked it out without even needing a court order. So I question a lot of the factors that the court ruled in the favor of father. Another one of the factors that I question is kind of the no-brainer factor, which says which parent has performed the majority of parental duties. Usually, always, the trial judge will find that the primary parent has performed the majority of the parenting issues. But she found that factor in the favor of father. And she even created a factor for number 15, which often is not used, and created that factor in the favor of father. And I want to address the fact that Mr. Sanko, he is an attorney in Chattanooga and has a healthy income and a flexible job. He could go to Pennsylvania, to the mother's hometown, and get a hotel for the weekend. That would not financially strap him at all if he's complaining about the hour move from one location of Pennsylvania to the other. So he could do that, and my client would be perfectly fine if he did do that. So his reliance at this point that the move from one place to another in Pennsylvania is questionable. And my client, during all of these years, these 7 years, was a single mother who had just gone through a divorce, who had just gone through a Court of Appeals decision, and she was working on her education. And that's why this court allowed the move. And generally, when you're working on your education, there are a couple of moves. I know I moved when I was in college. It's kind of a normal thing to do, but she's bought a house now, and the kids have been in their same school for 18 months, all doing well, and have a close relationship with Michaela, who now is in Pennsylvania and is rarely going to see the siblings at all. And the last thing I want to point out is the parenting plan that Chancellor Fleener put down is unworkable. That plan requires the dad to drive to mother's house one time a month for a weekend with the kids so they can visit with their mom. And what's been happening is the two children have either been missing Friday at school or Monday at school to make it happen because it's a 10-hour drive. So that part of the plan is unworkable, and she divided the summer, giving 5 weeks to each parent, which limits my client's parenting time down to around 60 days a year is what it comes down to, which is less than what father even proposed. And what was strange is the court said, now that I have found a material change of circumstances, I've got to now look at the issue and maximize both parents' time. And she did the opposite of that. And I think my time's up.
It has. I've done this before and I've had absolutely no success. But I will tell you from a purely personal point of view, again speaking just for myself, that it's frustrating to watch parents that have apparently worked together for years for their children's behalf. And now you have one child who's going to turn 18 in April, and you have one child left at 14. And you've got capable lawyers on both sides doing this, and I just hope that you all have at least made every possible attempt to try to work something out for this last child that doesn't end up putting him in a terrible position. And that's my editorializing. I've done it before, and I've had absolutely no success at it as far as I know. But you all have demonstrated the ability to work together for the benefit of your children before. And you did it for several years. Court thanks both sides for your arguments and your briefs. Appreciate it.